There we go. Now it's recording. We're talking family issues today. We're talking family, domestic violence, youth, all of that cluster. If that's going to be difficult for you, I'm sorry I'm not in the room where it's easy for you to discreetly walk out. But yeah, take a break, look after yourselves. I've chosen this picture. I kind of like this picture. This is the sort of pictures that were in the movies when I was growing up. It's Tarzan, and it's cute because Tarzan was this dude that lived out in the bush. He's a white fella, so of course he's superior to everybody else in the area. So there's a lot of sociology to look at in that space. But also, as the movies got more popular, they felt that he had to have a family, and the family structure that they surrounded him with was very, very standard Western. There's his wife, his child, maybe an adopted child there that's just a little bit different. But they had to have one man, one wife, one child, all very happy together. This was the basis. And sorry, I chose one movie. I could have just as easily chosen even the most freakish families you can think of when I was growing up. The Addams Family, the Munsters, they all had that fairly standard nuclear family bit to it. They couldn't bring themselves. The Brady Bunch, for those of you familiar, a blended family. Really, it was an excuse to have 6 kids in a small space. They never ever mentioned the dead or departed or whatever the story happened with the previous partners after the first episode or two. Nuclear family was basically what was presented to us as the regular, as the norm, as the one and only way it's ever been. Our laws reflect that. It's not quite true, but there you go. End of this session, you should have a general understanding about family law, a general understanding of domestic violence law. I'm not pretending I'm going to go into tight, intimate details on this one. But just like all the other areas we're looking at, you would need to take into account it's not just the legal, it's not just the legislation and the common law, it's not just the ethical. I am going to focus to begin with on the legal stuff. But don't confuse yourself thinking that's the only bit that matters. As with all of these areas, there's others that we need to look at as well. Okay, now apparently the main function of the family is the care and protection of its members. From a legal perspective, people are laughing already. Why are you laughing at that concept? A jaded view? Yeah, it is a little bit jaded. It's interesting to look at the history, because when you start pulling things apart, what we've always been told is the way things have always been really goes back maybe 2 generations at the most, quite often. So that's just interesting to be reminded of that. As society has changed, so has the structure of families. So, for example, on that first statement, the main function of the family is the care and protection of its members. I don't think my great-grandfather would have said that. I think he would have said the main purpose of the family is as an economic unit to form alliances, to keep structure going, and to continue the family name. The family as a whole, not the protection of its members. It's if we have to throw one of the members under the train to support the family and to support the family name in the company, we'll do that. As society's changed, so has the structure of the families. For example, Aboriginal Torres Strait Islander customary marriages and family relationships are a little different. And there's efforts being made of, so what do we do with that in the law? Traditionally, going back a fair while, I've had it from a couple of different sources that the Wiradjuri custom, and possibly a broader Aboriginal custom, was in fact throughout your life you plan to not have one partner, but you plan to have 2. Have an earlier one when you're getting used to the whole story, and you have a later one to take care of you in older age, for example. So it's just a different style to the supposed monogamous that we have. De facto relationships are being recognised in law. Same-sex relationships are recognised in law up to a certain point. Single-parent families are far more frequent and common and recognised. than they used to be, certainly more recognised than they used to be. Blended families, extended families, you get the gist. Family law is trying to change to extend protection to all members of the alternate family relationships, but it did have a system where a lot of the laws, a lot of the foundations were written at a time when these weren't recognised so much. They may have still been around, but they weren't recognised in law in the same way. So, let's take a little look at what this means. Marriage, the voluntary union for life of one man and one woman to the exclusion of all others. That might change one day. There's been a bit of debate. Don't know if you've seen it. It's in the papers. If you haven't, you should read more. A valid marriage is between one man, one woman who must be adults and who must not be closely related. Beyond that, the law's not really drawing a whole lot, although the law is saying that we'll get to reasons for separation, but it is saying that they mustn't have already been married. Sorry, they must not already currently still be married. That's a crucial issue. There are legal rights, there are legal obligations on the both husband and the wife. For example, issues relating to financial support of each other, maintenance, that's a legal imposition, a legal obligation that's recognised when people are married. And I'm taking the broader look at marriage here as well. Property, so the length of time that the parties have been married, what contributions they've made, that changes the rights and ownership of the party. Even though the law on one hand is saying that a house might be completely owned by one party, or other property might be owned by one party, it can transfer over. Where this gets difficult, also wills and inheritances factor in there as well. I'm not sure how many of you are familiar with the concept of sexually transmitted debt. Has anybody heard this term before? Just a couple. It's kind of tricky because with recognizing other partnered relationships, it's trickier now because Centrelink can say, we believe that you're actually in a de facto relationship, therefore you should be being paid as a couple, not as two individual people who happen to share a house. It's tricky. It's also tricky when, let's say I was living with somebody where, in a relationship where we hang out a lot together. It's hard to know, are we de facto, at what point do we become legally de facto? And the point that matters is when I go bankrupt and my creditors come knocking on my door and this other person answers, figuratively speaking, because they're going to say, on one hand it could be these people just happen to share a building and David's bankrupt but he or she isn't, so David's bankrupt, that sucks, we can't get our money back. Or they could interpret that as, hang on, David has shifted all of his property over to his partner. She's married, so he can claim bankruptcy, but there's a legal obligation there. She's got all the money. We're going to go after her to pay it. That's sexually transmitted debt. That's where people have found themselves trapped by their partner's bankruptcy or debts or whatever. It might not be bankruptcy, it might be debts in other ways, but it's a hassle because we can't clearly say for sure what's going on there. And clearly, people want their money back, so they're going to try to make it look like that partner, somebody, they want their money back. They'll go after whoever they can. It's a tricky area in the law. I'll just state it's out there. See a lawyer if that's an issue. Oh, they were looking so happy, weren't they? They're not anymore. Marriage could be declared void if the requirements aren't being met. So the requirements of being married in the first place is maybe consent wasn't freely given. So therefore this is a void marriage. This is a marriage that's not valid. Or if one party was married to someone else at the same time. This happens occasionally, but it's tricky because your marriage celebrant, your minister, whoever it is going to ask, either of you married, are we sure we've gotten rid of that old marriage? If they say yes, let's look up the records. There's a registry, birth, deaths and marriages, that keeps a track of these things. I do know of a couple of cases where people have, very romantic, they've gone off to Vegas, gone overseas, got married, perhaps Elvis, perhaps a helicopter was involved, all that fun stuff you do in Vegas. They've come back. If you go overseas, I feel like I'm giving you hints here. If you go overseas to get married, they're not going to look up the Australian Birth, Deaths and Marriages Registry. So therefore, I have known of 2 cases where people have married somebody not knowing that that person was still married to somebody else, because the checks don't work internationally. What seemed like a nice romantic deal was actually a scam to get around the laws. But it's rare. But you do tend to hear about it when it happens, because we all like to gossip. So if one person was already married, then that marriage is void. It's counted as null and void. It's no, it doesn't count there in the first place. Separate to that is divorce. So being able to say the marriage, we thought it was real, but it's not. It's dead and gone. Divorce is a little different. Divorce is, in Australia, since the mid 70s. The only thing that needs to be demonstrated is that there's an irretrievable breakdown. The spouses must live separately and apart for 12 months before a divorce order will be granted. Technically, there are people who have apparently said we were separated but we lived under the one roof. That's a rarity, but due to the poverty, they couldn't afford anything else. Generally speaking, let's stick with they need to live separately and apart for 12 months before they will say, yes, this is a divorce, this is irretrievable breakdown of the marriage. Prior to the 70s, it was a little different. You actually sued your partner. So it was what we've described here on the screen as no-fault divorce. It's just saying we both agree it's done, wherever possible. Previously, you actually had to prove that the other party had done you wrong and sue them. So there was an industry in poking around windows and taking photos of people screwing around with somebody else to prove that I was the wrong party because she was seeing somebody else. It was messy. It was ugly. There were lots of people who were just plain separated and never got a divorce because they didn't want to do that. So if you ever actually look at the statistics for divorce, you'll see this absolute spike in the mid-70s of a whole stack of people who chose to get divorced because they could finally legalize, finally formalize the difference there. But it does mean that they couldn't remarry either because they're still technically married. When it comes to property settlements, the courts are going to look at a few different factors. They're going to look at who contributed financially, who contributed non-financially to the relationship. So they're working out who gets how much property. Those are both factors. They're not just looking at the financial contributions. So we have a couple here. Just because this one here earned all the money doesn't mean that this one here walks out with all the money. They could be looking at non-financial contributions such as this one here supported that one to stay alive, to keep them fed, to pay all the bills, to run around the house, to do all the organising, to do all the work that didn't get paid, to support them through their college, their university. They'll take into account the age of the parties, they'll take into account the income, the childcare factors, and any other thing that's specific, but the financial and non-financial, the good catch-all. That's not to say that people need to wait until the divorce to make a binding financial agreement. So this is one of the things that lawyers have started suggesting, I've noticed, is to say, rather than wait 12 months and then we start talking about property, let's make an agreement now. Let's make an agreement that we'll sell the house and that you can have some and I'll have some. Let's not have a 12-month period. The way some people were treating it is, let's use 12 months to build our case that I deserve the biggest amount because I hate that bitch/bastard. Let's build our case now. That's not quite, that's what they're trying to veer away from. So it can be a binding legal agreement to separate, to disperse, to separate things prior to the formalisation of the divorce. Trying to get away from the ugliness of it all, the law is trying to provide dispute resolution structures and processes to help people just agree to an amicable termination. Lots of big words on the screen at the moment, being very legal today. So dispute resolution so that people can not have to, the extreme was the pre-70s stuff, was the having to sue, but still trying to say, okay, how can we actually agree to as much as possible? And the court is actually focusing more on reconciliation to a degree. That doesn't mean getting two people back together again. It means them being able to find a working relationship. Encouraging compliance rather than forcing it through fines or penalties or legal sanctions like that. Just getting people to agree is better than the rule. That's really all I've got to say about marriage from a technical, formal perspective. Parents and children, there is the convention. Do you remember me talking about international conventions? Previous sessions we talked about the big one, the Declaration of Human Rights, and there's been various conventions since then. One that you're likely to come up with more than any of the others is the Convention on the Rights of the Child. It unfortunately gets shortened to just the acronym of CROC, but nevertheless it's a serious one because Australia has signed on to it and we're trying to make it, because we agreed on an international level, we'll go with this rights of the child. That means we then have to review all of our legal structures and go, yeah, okay, are we actually meeting those obligations? How are we doing it? So it's influenced family law. It means within the family law, within that divorce settlement arrangement, there's legal and moral obligations to the children. And in fact, the best interest of the child is one of those terms that you hear constantly, because that's, from a legal perspective, what should be the focus of, and an ethical and moral, if you like, that should be the focus of the law in making determinations. So the children have the right, under the convention, to the care and protection of their parents, the right to an education, right to medical treatment, right to an inheritance, the right to know their cultural history, their cultural background, the right to access to their families. There's a subtle nuance there that sometimes people miss. That's a child's right to see both families. That's not, both parents. That's not both parents' right to see the child. When it's talking about the best interests of the child being the central feature, it's saying the child has a right to see their parents. Subtly different from the parent has a right to see their child. It means if the kid's saying, seriously, I'm not liking it, or I don't want anything more to do with that parent, they're going to be taking that into account. Depending on how old the kid is, that will be the crucial factor. You'll often hear your clients complaining, I've got a right to see my child. Not quite. Your child has a right to see you. If the child's not wanting that, then that's a different right. Domestic violence or domestic and family violence. I'm moving through all of these areas kind of quickly to give you an overview. There is plenty more in the links. It's just that it's hard for me to know where to stop with all of these, but I'll give you an overview. Domestic violence, also known as domestic and family violence in some communities. It also has a few other names in different parts of the world. I'm just curious, how many people are more familiar with domestic and family violence than domestic violence as an expression? I have a show of hands, DV, domestic violence and domestic and family violence. Not many. Okay. In more remote areas and in more Aboriginal areas, I've seen domestic and family violence talked about a lot more because culturally, traditionally, it's like a lot of European families actually. It's not that nuclear family is the core of the world mentality. It's the extended family is my people. So the violence extends to family members across the board, not just those you happen to be living with. So anyway, you'll see DFE tossed around in some spaces. Legally, domestic violence often shortened to DV, but it varies from one state, one place to another. Every state has its own rules around this. There's been attempts to try to make it consistent, but the language and the expectations vary. So from a legal perspective, there's a couple of different terms you want you to be familiar with. One is domestic violence. Violent, threatening, harassing, offensive behaviour by a person, getting up to the crucial part here, that's directed towards their partner, children, relatives, or other family members. That last part there, directed towards their partner, children, relatives, or other family members, is important because domestic violence is one legal term. Another, sorry, that can include physical, damaging property, being harassed, or doing that towards the partner, relatives, or other family members, or threatening to harm the pet. But that's still within the family. Contrast that with personal violence. We're talking legal terms here, remember? It's similar, but it's by people who aren't related. So the difference is the way that the law treats it. The actual way that it's felt or experienced could be incredibly similar, but personal violence as opposed to domestic violence, personal violence is people who aren't related. So someone you know from school, university, work, people you met on the internet, people you don't even know, but you know that they're harassing, bullying, intimidating, attacking your dog, whatever. I specified this is a legal issue. The real time that it makes a difference is what type of protection order. And there's subtle differences. So if you're not needing to know the nuanced differences, personal violence and domestic violence are treated fairly similar, but there's little differences. But there is a domestic violence order and there's a personal protection order. These are orders that can tell, I'll get to those in a moment. New South Wales domestic violence order is known as an AVO, so an apprehended violence order. Personal protection order is known as a APPO, apprehended personal violence order. So in New South Wales they actually mimic a fair bit, but again, words are different. I went hunting for some policies, hunting to find out how these things are done. I just thought it was interesting that I found this document that had for official internal use only from the Federal Police splattered all over the top of it, freely available on the internet. So what I'm telling you now is the internal policies of the Federal Police when they're responding to domestic violence situations in the ACT. According to that internal document, police would prefer to arrest and detain an offender to speed up the legal process and retain control of the situation. So basically, an awful lot, way too much of police work on a day-to-day basis is they get called out to a domestic, a violent situation happening within a house. It's a pain for them. They don't know how extreme it's going to get. It's frequent, it's common. They are at least responding. There was a time when they said, oh, it's a family matter. Don't really like to get involved. They're now saying it's simpler and easier for us to actually arrest somebody, the offender, the violent person, speeds up the legal process. If they don't have enough evidence to arrest, then they can put in an emergency protection order. They can detain somebody for up to 4 hours while they get an interim order. The issue with this is they don't actually need to, there's a balance that they're struggling with all of the protection orders, and that's because they're trying to say, like on one hand they could say you're innocent until proven guilty, we can't do anything until we've actually had that proved by the court system. If they were to take that extreme, then it means that they can't really put any protections in immediately for what's clearly a violent situation in their opinion, or what's probably a violent situation. They can't put any protections in until the court case has been through. That would take months. So instead we have a system of AVOs, of these orders that say you're not to act that way in future. You haven't been found guilty, but there's certain things we can order you not to do. And if you break that order, then you're breaking the law, and we can arrest you just like that. So that's where they've gone away from this. You have to prove it, but it does mean that if you've got an AVO, or if you hear of somebody who has an AVO against them, that doesn't mean that they've been found guilty. That theoretically, and in some cases truthfully, means they haven't actually been violent. It means they've got an order against them to make sure that they don't. You've got an order against them that makes it really quick and easy for police to say, we've got an order here. You are ordered to do certain things. You're not doing them. You're coming with us. The tricky thing with these orders is that the police themselves can't issue them. It's not putting in the protection that we need. We need to sort of say the courts can decide, make rulings. The police can provide evidence, and the courts actually make the final rulings. In these cases, the protection order is still issued by the court, still issued by a magistrate, except that these incidents often happen of an evening, heat of the moment. So what they've set up is a system where the police can say, we're talking to the court now. You have to sit here and wait while we got that order from the court. They can print that on the spot out of their dashboard of their car or motorbike apparently, and they can then hand that off, but they've still got to get the magistrate saying, are you being too flippant with this? Okay, so prove to us. Okay, that's enough evidence for me. Here's your interim protection order. Hand it to the person and say, you've been told now. And it can say things such as, so it's made by the court generally. I was just talking about the crisis incident of an evening, but it can also be applied for by actually going down to the court if somebody's considered. So the interim order is the urgent one. You can make the application directly to the court. Their advice is, advice from a different document now is, get there early. It takes a bit of time. Get there before 11 AM. They usually won't accept apparently after 11. If the magistrate makes an interim order, you get a return date for a confirmation of that. The interim order can be made pretty quickly. It's at least 21 days later. It's usually about a month apparently. The orders can ask them to, number one, don't be violent. Stop approaching you, your home, your place of work, other places where you'd usually attend, like your school, university, swimming pool, and don't contact that person by phone, writing, or on social media. Remember, this is a person who hasn't been convicted yet. He's being ordered to do these things. They're pretty reasonable. They're not saying you must give up your job. They're not saying you must pay a fine. They're saying, hey, don't be violent. Don't, just chill. Separate. Don't see each other. There have been cases you can probably imagine this. I'm hoping not too easily, but there have been cases where two people within one class at a college or university or even school need to have that separation. That gets tricky, but it can be done. It means that people need to rearrange their time. The order can actually say, stay at least 100 meters away from this person, except during class time. It can make little variations like that depending on the individual circumstances, but they tend to be fairly boilerplate and say much the same thing. So yeah, to enable both parties to attend classes. If they keep going in breach of that, then they can be charged with a criminal offence, arrested and sentenced. It's not to say they couldn't be charged anyway for being violent. So the violence is simple and easy. But approaching somebody, coming too close to them, approaching them on social media, ringing them up, those aren't legal offences in their own right unless there's a protection order in place. I'll just bring this up briefly. Every different state, we talk about the order being a domestic violence order, for example. The victim is the aggrieved person, the perpetrator is the respondent. The language shifts from every state. I couldn't find two states that said the same thing. Aggrieved person, protected person, the complainant, the person in need of protection is another term I've heard quite often. The respondent, the defendant. The language has shifted, so just be aware that they largely mimic each other in their practical sense, but in the finer points legally, there's variations. We're sticking with ACT version. I'm going to stick with that.